The Ruia family may have come up with a complex financial structure, as Damenka said, to bid for the Essar Steel assets when the final resolution plans are submitted. The structure, first reported by the Economic Times, may allow the promoters of Essar Steel to bid without clearing their overdues, which is what is required under the Insolvency and Bankruptcy Code. Now, Vishwanath Nair has the details on how this structure could play out. So over to him first, and then we debate it. Vishwanath.
Right, yeah. So as you discussed earlier, that the structure is being proposed, or at least it looks like it, so that the Ruia family can go ahead and bid for the asset through a consortium, through an SPV, which has VTB as well as SSG Capital. And we already read this in the Economic Times yesterday, but then more details are emerging wherein they're saying that this kind of SPV that is going to come out is a Mauritius-based STB, will have, wherein VTB will have about a 40% odd stake. SSG will have a 30% stake, and the remaining 30% will be a Singapore-based trusteeship. Now, this is important because for the Singapore-based trusteeship, the beneficiary is Revant Ruia, who is one of Essar's co-founders, Ravi Ruia's son. Now, he's also on the board of a couple of Essar Group companies, but not Essar Steel, or at least that is what our sources are telling us. So, what they aim to be doing this is that they will take away that whole, people who are acting in concert or people who are related to the company, they will take that rule out. Secondly, because the ownership of the stake eventually lies with the trusteeship and not with any of the promoters. The promoters are only beneficiaries of the trusteeship, so they will not have to pay up those excess dues that the promoters are expected to pay to the bankers before they can actually bid or be eligible for bidding. Of course, all of this will be tested out as the case moves forward, and 29th of January is the last date when the promoters will have to submit their bids, as will everybody else in the system. And then after that, the lenders as well as the resolution professional involved in this, Satish Kumar Gupta, they will all take a call on how to go ahead from there. That's what we know from our sources right now. Yeah.
Okay, so I have a couple of questions, and both of you.
I just want to know, before we get into the conversation, what did Essar say? Did they confirm this structure? Did we get a statement?
So they did not deny it. Essentially, their statement said that they have submitted an EOI. The EOI said that they will be working with VTB Bank to work out a resolution bid. Now, this was before the government passed that ordinance, which essentially blocked the promoters. After that, they've said that they've been working with the VTB and their lawyers, and they're trying to come up with a structure after which they will submit a bid. That is for sure.
Okay, so they didn't confirm the structure, but they didn't quite necessarily deny it either, is the comment that you got from them.
Yes.
Yeah, sorry, I just wanted to...
No, absolutely. We should have had that comment on the plate as well. But I think, okay, so my first question is this. So if we go to that first, the breakup of what the SPV could look like. Now, it has VTB as a 40% shareholder, if that's what the term is for a SPV. They have SSG Capital at 30% and the Singapore-based trustee at 30%. So my first question is, even if the Ruias are the beneficiaries of this trusteeship, are they in control of this, or are they financial investors? How does one look at that?
No, they're not in control because they'd have a third of the company.
Yeah.
But one would have to see, and especially if the trusteeship only names them as a beneficiary and not to any of the trustees themselves who are managing the trusteeship. So the structure of that trust also needs to be kept in mind. However it evolves to be, I would imagine. Vishy, I'm sure you'll pitch in when you think otherwise. But
these, well, you're right, Menika. As and when these bids will actually be submitted, that is when the structures will be clearer to people involved in the system. Because at this point in time, remember, this is being worked up at Essar between VTB Bank and SSG Capital. So it's a conversation that is being held between there. But on the 29th, when they actually submit the bid, that's when we'll come to know who is in charge of the final SPV. Who will actually be running the company, who will be in charge of the management. These things will somehow become clearer by the end of the month.
Simple understanding of how companies work is if 70% is not in your control, then you're not in control.
Exactly.
Even if you were a trustee on the trusteeship, and even if you were a beneficiary of the trusteeship, if 70% of the SPV is not in your control, then you're not in control of that SPV.
Yeah.
And if you're not in control of the SPV, now the question then remains is it still kosher within the various eligibility criteria that have been laid out by the law? Or is it not? Now, you considered to be, in some fashion allying with these partners to make the bid? Because I think what in intent at least, right? And this ordinance and subsequently an actual amendment to the Insolvency and Bankruptcy Code will only now get tested as we see the resolution processes move forward. But in intent at least, they did not want promoters of distressed companies to be able to participate in the bids for these distressed companies if those promoters had not paid up their overdues, right?
Yeah.
With all the other caveats, saying if you were a corporate defaulter for a year and more and all of that.
Yeah.
So I think if that's the principle, one has to see whether this falls within the principle of that or it only falls within the lettering of the law. We could speculate, but I think we'll know better. But I wouldn't be surprised that dozens of promoters, not just the Ruias, but dozens of them would be looking at structures that would allow them to participate in the repurchase of their own asset in some fashion or the other with external capital, so as to be able to sort of regain in some ways the ownership of that asset.
Absolutely. And Vishwanath, from what you picked up from your sources and the stories up on the website, they did think that this would prevent or not require the Ruias to pay that overdue amount.
That's right, because essentially they're not in control. As Menaka said earlier, 70% of the company of this SPV will lie with VTB Bank. So essentially they are not putting the bid as Ruias, but are part of, in some indirect fashion, of this bid. Also important to notice, and this is a point that Menaka made about dozens of companies trying this, 55,000 crore, guys. It's a massive asset. It's the largest asset being restructured under the Insolvency and Bankruptcy Code. So whatever happens here, however this turns out and what the lenders are going to say about this will sort of become precedent, will become a case point which will be debated amongst other promoters, for not only the 12 but also the 29 that came in later. So it's an important case in that fashion.
Just important to remember, what you can't do directly under the law, you can't do indirectly either. I think that's the principle that works in the way you interpret all law. Will lenders be excited about something like this? They probably will, because you want to be able to return the asset to a person that is able to run it and is most familiar. So I don't know how much lenders will oppose if such structures are deployed.
Not lenders, but I don't know, the courts, perhaps, if they are trying to uphold the principle of the IBC ordinance.
By the way, competing bidders, let me tell you, if there are competing bidders, and let's for a moment pretend this is not just Essar we're talking about, right?
Yeah.
In other cases, there will be competing bidders, and competing bidders might also object to these kinds of structures being deployed. So there is a large constituency of people out there who will want to have a say in whether this passes muster both with the spirit and the text of the law. Absolutely. And I'm guessing wait and see. I'm sure they are also. I'm sure that no promoter today, after the ordinance and after the fact that they did not change anything in the ordinance, even when legislating it in Parliament, they get the message. So I don't think they would attempt to subvert the process.
Question here. Since you have discussed and debated this issue in detail, in those days, did you get this impression in any way that a minority shareholding of the existing promoter could be allowed? Because there were several bidders who were willing to, partner with the promoter.
So if you remember the text of the law, it simply says that if you want to be eligible to bid, you would have to pay your overdues, correct? It does not say eligible to bid in full, in part, as part of an alliance. So that's why I said what you cannot do directly, you cannot do indirectly either. So that's a very amateur reading of this. There are many very well-paid lawyers who are reading this and, putting it together. All I'm saying is I think promoters in India got the message. The government made a very clear message, and they got the message. Now, I don't think they would be silly enough to want to try and subvert that, because no matter what structure you use, it is going to become evident what structure you were trying to indirectly or directly use. So I'm sure that they're going through all the legal hoops to figure out whether they can use this or not use this. It'll be interesting to see how the final
final bid shapes up. Yeah,
right?
Exactly.
Yeah.
That's right.